first case that will come before us today is State versus Massey, and it looks like we should start hearing from the appellant. So we have a monitor over there with time that you can, that will maybe be able to assist you, or however you want to work it, but you have 15 minutes.
Thank you, Your Honor. May it please the court, Brian Williams on behalf of the appellant, Anthony Massey. I know that the court's already read the briefs, and I know that the court, historically, you've had to deal with sometimes briefs that have 3, 4, 5, maybe even double-digit numbers of assignments of error. This one is one assignment of error and one issue that I hope I distilled in my brief to make it clear, and that is, was there reasonable suspicion to stop and then probable cause to arrest my client? The authority for that was cited at page 6 and 7 of our brief, United States v. Stanford and Terry v. Ohio. In the Supreme Court case in Ohio, State v. Vogel says that the propriety of the stop, in light of all the totality of the circumstances, that's how it's to be reviewed. The trial court, in its opinion, accepted carte blanche the testimony of the trooper, Officer Boyer. And there is the case law that says that if there's credible, competent evidence, then the facts that the trial court found are to be accepted by this court. And that's the problem. The evidence that was presented to the trial court was not credible and it was not competent. And even if it was, there's still an independent review and analysis of the law to the facts that may have been accepted by the trial court. In my brief, I indicated that there was no independent review by the trial court of the dash cam of Officer Boyer. And I base it on the fact that quite often in an opinion, the court will say, we've reviewed the testimony of this, the testimony of this person, the documents submitted. It's blank, there's no mention that it ever was looked at, despite the fact that it was absolutely the most critical piece of evidence against my client. At 1 minute, 3 seconds of the dash cam is the only objective evidence of Mr. Massey, and what it shows is his truck tire touching the center line. He was driving in the left lane on Arlington, coming north toward his home. The center line is the broken white line, and at best, his tire may have touched the white line, and even according to Officer Boyer, for 1 to 2 seconds. That's important because 451133, which is why he pulled him over driving in marked lanes, it's required that the car go entirely either over the center line, if you're like he did, the white lines, if he's driving in the right lane, go over the fog line, or to go over the center line, left of center. That did not occur, and the authority for that is, and I added it to my brief last week as authority for oral argument this morning, State v. Huffman out of the appellate court in Lucas County. And ironically enough, the reason that Mr. Massey was pulled over, allegedly driving over marked lanes, he wasn't charged with that and never entered a plea to that. It was simply the DUI charge, and it was a felony because 20 years ago was a bad time in his life. He had been convicted of a felony, and every subsequent arrest for DUI is subjects the defendant to being charged with a felony.
Counsel, let me ask you a question. Would you agree that that would constitute reasonable suspicion if his tire did go over the line, the white marked line?
If it completely went over, Your Honor, is that what you're asking?
Yes.
Yes, but that's not what the evidence shows. It touched the white line. People all the time drive in the right lane and hug the fog line. There's nothing wrong with that. There's another part.
Hugging the fog line is on.
No, I'm simply saying, trying to illustrate. I have other cases dealing with this issue. If the evidence showed that he had been completely over the line, I probably would have advised my client that you simply need to go before the court, enter a plea, and, you know, beg for mercy, because there would have been reasonable suspicion. But,
Well, let me ask you this, officers can make mistakes, right?
yes, Your Honor,
Maybe in his view, he did go over the line.
that's not what he testified to, though. It's not what and they showed the video.
Well, I thought he testified that he went over just for briefly for a second or two.
It was that he touched the line. I don't believe that he said that he went over. I'm not gonna, if I'm erroneous in that, I apologize. You know, I did the hearing, I don't remember him saying that he went over. He alleged that previously, before he turned on the dash cam, that he had witnessed my client supposedly going over the line from the distance of a football field away
Well,
at night.
but the point is, he did say that he thought he saw him go over the line.
That's not shown by the independent evidence.
But, well, that wasn't on at that point.
Correct.
There's no evidence to say one way or the other. It's just a matter of credibility of the officer.
Correct. And that puts the defendant and appellant in a very difficult position, because we have to go with what the discovery is that's provided in the testimony. It could almost be self-serving to simply say, well, I saw him commit a more egregious violation, but, you know, ironically, it's not shown by the independent evidence. And even,
don't we see that all the time?
perhaps, but I think what the court now needs to do is go to the totality of the circumstances. Assuming that Officer Boyer's testimony is true, that from a football field away at night on a busy street with reflections and streetlights, if you're looking at the video, that he saw him go over the center line, actually go over it, and then that's what prompted him to start following it. When he's following Mr. Massey, again, it's a second or two that he touches the white line. Mr. Massey is not weaving. He's driving straight as an arrow. He gets to his street, turns on his left-hand signal, makes a proper turn, doesn't cut it too short. When the lights go on, he immediately pulls over he doesn't fumble for his license. So, you know, what was the impaired driving? I mean, that's the second part of my brief, is assuming that you had reasonable suspicion to pull him over, which we believe he did not, there still has to be some type of impaired driving. And I've cited case law that because you have flushed eyes, because you may have committed a de minimis traffic violation, that in and of itself does not constitute probable cause to then go through the testing procedure for a DUI. I also would point out that 451133, which is again, the alleged violation, he wasn't charged with that, didn't plead to that, but there's a second part of the statute, and if I could quote it for the court, it's a vehicle or trackless trolley shall be driven as nearly as is practicable, entirely within a single lane or line of traffic, and shall not be moved from such lane or line, and here's the part that I want to emphasize, until the driver has first ascertained that such movement can be made with safety. So Mr. Massey is driving home at night, it's around 11:45, I believe. He's staying in his lane. If he may have touched the white line, what's to say that he did not objectively determine, I need to stay as close to the center line as possible. Why? I don't want to go over the center line, which could cause problem for oncoming traffic. I also don't want to be too close to the center line, because oncoming traffic at that time of night could come left of center and cause me a problem. So that part of the statute is incorporated in Part A1, and there has to be proof or reasonable suspicion that he was driving in an unsafe manner. And that question wasn't asked by Officer Boyer of my client. Why did he touch the line? In fact, Officer Boyer said, and this is again, going back to Judge Carr's question about, did the officer make a mistake, or did he make a determination that he saw a violation? In his report, he claims that my client was driving, quote, all over the road. There is absolutely no evidence of that. Again, the two pieces of evidence that could have given him the reason to pull him over was his seeing him, the driving out of the lane, not shown on the video, and then the 1 to 2 second touching of the line. And in State v. Huffman, which I'm relying upon, that court reviewed the evidence, looked at the dash cam video, and made a conclusion that we've looked at this dash cam video and it overrides and refutes what the officer testified about. I'm asking the court to do the same in this case. Is if you look at the video, it's going to show what I'm saying, that Officer Boyer's testimony is not credible. He's saying he was all over the road. He was not. If he wasn't all over the road, then how is it credible that he, quote unquote, saw him go over the not the center line, but the broken white line in his lane? How is that? How can the court determine that that's credible when there's these other things that are objectively refute his testimony? I think it puts it in doubt.
But isn't it true though that the dash cam's not on all the time?
That's correct.
There has to be something that makes the officer turn it on so that he can now watch what's going on, record what's going on. So there had to have been something that prompted it. Would you agree that there had to have been some reason to turn it on?
He says, that's what he said. And again, officers, I'm not in any way trying to knock what they do in terms of protecting public safety, but this was an officer who in 2017 worked 225 days and made 247 DUI arrests. That was in the record. That, I call it trolling. Maybe that's allowed, but I mean, to me, it puts into doubt his credibility that he's looking for any type of infraction. You know, he sees a fly on the wall, well, there must be some type of problem here.
So was that asked of him, the testimony, how many DUI arrests he had?
I'm sorry, Your Honor.
How did that come up in the suppression hearing, how many DUI arrests he had? Was that?
That came up on cross-examination.
Did anybody ask him how many he had arrested that were not, how many cars he pulled over and they were not DUIs?
No, he had said that he had pulled over 247 people on suspicion of DUI. He was not asked as to how many of those pullovers led to a conviction, but he pulled over 247 cars in 2017 on suspicion of DUI.
I'm not necessarily talking so much about conviction, but were of those 247, were they all charged with DUI? Is what I'm trying to say.
Yes, Your Honor, that's what he said.
So he's saying he's pulled over 247, and of those 247, every one of them was charged with DUI.
That was my understanding. I did not see the actual law. But the point is, and again, I understand that the officers have to have broad discretion, and it shouldn't be questioned when they're protecting the safety, but there comes a point in time where there's a line that cannot be crossed, and I think that line was crossed in this case, and Mr. Massey was unfairly convicted, and we would ask the court to now overrule Judge O'Brien's decision and deny the suppression motion, and if you do so, then that would vacate his conviction.
Okay, I just have one more question. I'll see if the panel has any other questions after judges. But okay, so I want to understand when you're saying that the officer alleged he crossed the broken line. Are you talking about it's a 4-lane highway?
Yes, Your Honor, it's Arlington Street running, and it is 4 lanes at that point from Cole Avenue down, I believe, to Waterloo Road.
And I thought it was Arlington. I was just trying to picture that. Okay. All right. Thank you. That's all I have. Well, we will take the matter under advisement. We will issue a written opinion that will be sent to you as well as the other side. Thank you so much for
Thank you,
presenting
Your
your
Honor.
argument.